Why shouldn't I just send you to prison?
The newborn passed away in its sleep.
We are back on the record in 2023 CR 4371B, State versus Moreno Vasquez. Can I have parties announced?
Megan Gowan, Lorna Espinosa for the state.
David A. Garcia, attorney for Marco Moreno Vasquez, judge.
All right, and we do have an interpreter here. If you can state your name for the record, please, to the interpreter.
Mariana Rios.
And she's previously been sworn. The deputy has informed me that a verdict has been reached in this trial. Are both parties ready to receive the verdict?
Yes, sir.
We are, judge.
All right, Deputy Laura, are the jurors ready? Let's bring them in.
All right, great.
All right, ladies and everyone, please be seated. Ladies and gentlemen of the jury, it's the court's understanding that you've reached a verdict in this case. Is that correct?
We have, Your Honor.
And is that a verdict as to each count?
Yes, ma'am.
And are those verdicts unanimous?
Yes, ma'am.
All right, if you'll hand the verdict form to the deputy, please. All right. If the defendant will please rise. Count one, to the charge of murder, it states, we, the jury, find the defendant, Marco Moreno Vasquez, guilty of the offense of murder as charged in count one of the indictment. Count two, deadly conduct. It states, we, the jury, find the defendant, Marco Moreno Vasquez, guilty of the offense of deadly conduct as charged in count two of the indictment. You may be seated. Does anyone wish to have the jury poll?
Not the state, Your Honor.
We do, judge.
All right, ladies and gentlemen, I'm going to ask you if this is your verdict in counts one and counts two. If this is your verdict in counts one and count two, I'm going to need for you to respond yes. Does everyone understand? All right, so we'll start at the end here and then we'll go to the back. Is this your verdict?
Yes.
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 Is this your verdict? Is this your verdict?
Yes.
All right, we'll start on the back row. And of course, the two alternates, you were not a part of the deliberation, so we'll start here. Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? Is this your verdict? All right, so ladies and gentlemen, what I'm going to do is I'm gonna have the deputy take you back to the jury room. There are a couple of things that I need to address before we bring you back out. Do not think about this trial again unless you're in the box, all right? Everyone, please rise for the jurors. You may be seated. State, with regards to punishment, are you planning on having any witnesses?
No, Judge.
Defense, are you planning on having any witnesses?
Judge, the one witness that we called to be here is not here. We don't expect him to show up. So I need to speak to my client to see if he wants to testify.
All right, we'll give you a chance to do that. Is the courtroom next door available? Because he may want to speak to his client in private.
Yes, it is.
All right, so you can speak to your client next door with the interpreter.
Thank you, Judge.
All right, you're welcome. All right, so we're on the record in Marco Moreno Vasquez. And I do believe, counsel, that before jury selection, your client elected to go to the jury for punishment if he were found guilty.
That's correct, Judge.
And you're asking that that be changed to the court?
After conferring with my client, which I've been trying to do for quite a while, as far as changing it, he has finally decided to go to the court.
And state.
This time we're not in agreement with that, based on the jury selection and the jury being under the impression that they're going to assess.
All right. And state, you've stated before that you have no witnesses. Defense, are you going to have witnesses?
We do not, Judge.
All right, then we'll bring the jury in. Have both parties had a chance to review the charge? And what I can tell everyone, it's a basic charge.
I could just have
Sure.
just a minute, Judge. I'm sorry.
You guys going to use a...
And so attorneys, we're going to take up the closing arguments. It should be brief. And then the deputies will be able to bring your clients up and we will take care of that matters. But please give some time back if you are able to. All right, let's bring the jurors in.
All right.
All right, everyone, please be seated. All right, ladies and gentlemen, I'm going to read to you what's called the charge of court on punishment. Again, you do not have to memorize this. The original will be given to you when you begin your deliberations. Charge of the court on punishment. Members of the jury, by your verdicts in this case, you have found the defendant, Marco Moreno Vasquez, guilty of the offense of murder as charged in counts 1 of the indictment and deadly conduct as charged in count 2 of the indictment. It is necessary that the jury assess the punishment for these offenses. You are instructed that the punishment for murder, oh, I am so sorry. Please disregard everything I have just told you. State, would you like to make an opening statement?
No, Your Honor, we waive.
Defense,
No, Your Honor.
state any witnesses.
No, Judge, we just re-offer all of the evidence that was admitted in trial.
No objection.
All right, and any witnesses from the defense?
No witnesses, Judge.
All right, thank you. So, ladies and gentlemen, you can tell outside your presence, both parties had informed me that they did not intend to call witnesses. But both parties have now rested and closed as it relates to punishment. Now I can read to you the jury charge. Okay. Members of the jury, by your verdicts in this case, you have found the defendant, Marco Moreno Vasquez, guilty of the offense of murder as charged in count 1 of the indictment and deadly conduct as charged in count 2 of the indictment. It is necessary that the jury assess the punishment for these offenses. You are instructed that the punishment for murder is confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 5 years. Therefore, you will assess the punishment of the defendant at life or any term of not more than 99 years or less than 5 years for count 1. You are instructed that the punishment for deadly conduct is confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 10 years or less than 2 years. Therefore, you will assess the punishment of the defendant for any term of not more than 10 years or less than 2 years for count 2. In addition to imprisonment, an individual found guilty of the offense of murder and deadly conduct may be punished by a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you assess a fine, it is not paid to the victim or victims, if any, but is paid into the registry of the court. With regard to count 2, the defendant in this case has applied on written sworn motion for community supervision, stating, among other things, that he has never been convicted of a felony in this or any other state. Our statutes provide that where a defendant is found guilty of deadly conduct is charged in count 2 of the indictment, and the jury finds that the defendant has never been convicted of a felony in this or any other state, the jury may, within its discretion, recommend community supervision during the good behavior of the defendant. If the jury does recommend community supervision on count 2, it will be granted by the court. If there is any evidence before you that the defendant may have committed any act of misconduct other than the offense of which you have convicted him, you are instructed that you may use that evidence, if any, in assessing punishment in this case, but only if you find from the evidence beyond a reasonable doubt that the defendant committed such other act of misconduct, if any. In the event you have a reasonable doubt as to whether any other such act of misconduct was committed, or as to whether the defendant was involved in such other act of misconduct, then you will wholly disregard the evidence, if any, which may relate to any such matter. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, and any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the applicable law in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdicts if you should care to use them. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, each verdict must be unanimous, in writing, and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. Each party will have at least 15 minutes to speak to you on punishment. State, are you prepared to proceed?
Yes, Your Honor.
Ladies and gentlemen, we proceeded to the second phase of trial. During this phase, like the first, you will have the charge of the court. This shows the charge of the punishment. So here, in count 1 is murder. The range of punishment is anywhere from 5 to 99 years in prison. For count 2, that is a 3rd-degree felony, and the range of punishment is 2 to 10 years. Or in this case, you may assess probation. Now, at the end of defense's closing argument on punishment, Ms. Galloway will get up and ask you what the state seeks.
All right. Defense.
Thank you, Judge. Good afternoon. So we're back now on punishment. And most people don't understand the way the law applies to punishment. So you've heard on the 1st-degree case, the murder, that it's from 5 to 99. Okay? There's no probation on that. You get to choose between 5 and 99. That's why when we were selecting you, we had to make sure you could look at the entire range. Some people were going to be on the high end only. Some people were going to be on the low end only. So we had to make sure that you 12 could look at the entire range from the low to the high, to be fair to both sides. Now, as Marco sits there, he and I do not agree with your verdict, but we respect your verdict. We knew coming in that he had put himself between a rock and a hard place on some very serious charges. But that was done once he opened his mouth and spoke to those and didn't say the right thing. He should have told them that he was in fear for his life and he was being threatened by ATIS. Not only him, but his wife and his children. Okay. You clearly didn't agree with that version, but nonetheless, that's where he is. And now we're before you based on the facts that were before you in this trial. So remember, he still holds that he's innocent even though you have convicted him. He is now a convicted murderer and convicted of the 3rd-degree felony of deadly conduct. And he respects your decision. We just don't agree with it, okay? But we have to go forward and seek punishment now. So regarding the 5 to 99 and the 2 to 10, you get to choose. As the prosecutor and the judge have told you, and the charge makes it very clear, if you want to give him probation on the deadly conduct, you can't. Probation only goes up to 10 years. That's the maximum for probation. But the real question is, what do you want to do with him on the murder charge? Okay, because somebody died here. Can't take that lightly. We never have. It's a horrible situation. But by the same token, you haven't heard any evidence about the victim. And I'm not bad-mouthing the victim here. Please understand. I'm just talking about the situation that we all find ourselves in. Okay? So regarding punishment, understand that it's 99 or life at the max. Most people don't understand that 60 to 99 years is exactly the same thing. So life is considered 60. So really you're deciding between 5 and 60 years, okay? On most felonies that are not considered aggravated, the time that a defendant, somebody who's convicted and sentenced to prison, does probably a quarter of the time. Okay, that's not the case here. Murder is considered an aggravated offense. So whatever you sentence him to, he will have to do half the time. Let me repeat that. Whatever you sentence him to, he will have to do half the time before he is eligible for parole. Remember, the word there is eligible. Doesn't mean he will necessarily get it. The Board of Pardons and Paroles makes that decision. Some people get it, some people don't. Depends on how they do in prison and what the charge is and what their previous is, their previous convictions, their previous arrest history. Here, you've heard nothing. So I can tell you that Marco had never been charged or convicted of any crime before this case. I can tell you.
Judge, I'm gonna object, and can we please approach?
Yes,
Sure.
and I'll pause your time.
Thank you.
So
Where am I at?
You are at 10:54.
Let me clarify that. He's never been convicted of a felony in any county ever. Okay? So had he been, they would have brought that to you. They brought you nothing. Okay? So we have this case, which is still very serious. Nobody is diminishing that or minimizing that. Okay? So where I was on an aggravated offense like murder, a person will have to do half the time before they are eligible. I only tell you that because a lot of people get confused and then they send questions to the court asking what exactly everything means. So I think knowing that, that's pretty clear. So really you're looking at 2 to 60 years as far as actual numbers. Okay. So you get to decide what to give him on the murder and on the deadly conduct. He's been in this country over 20 years, working construction in his little farm/ranch. Otherwise, he had had no problems until ADIS came into his life, which was unfortunate for him and his family. He's got a wife and 3 children, ages 8, daughter, a boy who's 16, and a daughter who's 17. These were the people that he was so worried about regarding this whole case. So I don't say this to forgive him because a life is still taken, but I want you to understand where he's coming. So regarding the range of punishment, some prosecutors, and I've been doing this a long time, both in New York and here. So some prosecutors will look at the range of punishment and they'll say, you know, normally what I do is I start in the middle. Okay. So if you start in the middle, it's not 2 and 99, it's 2 and 60. So that's what? 58 years. And I cut it in the middle. So 58 years divided by 2, I used to be really good at math. 60 would be 30. So we're looking at what, 38 years? No, that's not right. 30 years would be 60. So like 28 years and a half or something, 28 years, 29 years, around there. So they say we start in the middle and then we look at the defendant's past, his history. And if he's done bad things in his life, we move that up. And if he's done good things in his life, we move it down. Here you've heard nothing regarding any prior bad acts as far as convicted felonies, shootings, anything like that other than this case. And remember, I'm not diminishing or minimizing these charges because they're very serious. But this is what you have to deal with. So using that chart, and I'm not saying that these prosecutors are going to do that, but that's what most do. And so on that case, we would be moving him down from 28 years. Okay. Now understand, you also heard from ADIS, who I submit to as a cold-blooded killer. They're probably going to say, so is Marco. Look at Marco. He's not a cold-blooded killer. Remember ADIS sitting up there who couldn't look at you? Did you see that face? I mean, I could look at him from my years of experience and tell that guy's a killer. Look at this guy. He's just not that bright. He's not that mean. He put himself in a really bad position, and here we are. And I appreciate all the time that you spent thinking about this case and giving him his day in court. Regarding the punishment, you know, ADIS took a plea to a cap of 38 years. What that means is he's going to come back before this judge. And I hope they call me to testify so I can get up here and talk about his lies. But nonetheless, the judge knows. She heard all the testimony. So she's going to have to sentence him from 5 to 38 years, 5 to 35 years, I'm sorry, and decide what to do with him. I suggest you think about that when you think about Marco. And I brought you evidence that Marco was not the shooter, was not the killer of Danielle. ADIS was. Marco was just a stupid patsy that ADIS brought to you, brought to the incident, to the killing scene. So I would hope that you'd give him some leniency there. But that's your domain. You get to decide. That's why this system is the best because you are his peers. And by the grace of God, you hope that you and your family members and somebody you know that's a good person doesn't get put in this situation. That a jury of 12 will look and understand the situation he was in, for better or worse. He clearly made a lot of bad decisions that day, only by even letting Adis come work for him. But somebody's dead now. You have to decide what you want to do. Regarding the probation on count 2, that's completely up to you. You want to give him 10 years probation on the deadly conduct? You want to sentence him to 2 to 10 years? That's fine. But on the murder, it's 5 to 99 or really 60. So I hope that you will understand he didn't want to testify because just like initially he wanted to testify in guilt innocence to scream out his innocence, we felt that the evidence was enough not to convict him. Now, when he could get before you and beg for mercy, he's decided that no matter what he says, it's not going to change the situation he's in. Whether he asks you for mercy, whether he tells you he didn't do it, I'm doing that for him. I ask that you be merciful to him and give him every opportunity you can to continue to have a life so he can be there for his 3 children. Thank you for your time.
All right, State.
Ladies and gentlemen, by your verdict, you have found the defendant guilty of the offenses of murder and deadly conduct. And now I come before you and I'm going to tell you the range of punishment. Regarding count 1, the range of punishment is anywhere from 5 to 99 years or life in prison. On count 1, that charge is not eligible for probation. And regarding count 1, I am asking that you sentence the defendant to anywhere between 35 to 45 years in prison. Regarding count 2, the range of punishment for that is anywhere from 2 to 10 years, or as has previously been explained, you do have the option to sentence him to anywhere from 10 years or under and suspend and probate his sentence to place him on community supervision. I'm going to ask you to deny his application for community supervision and sentence him to a term of 10 years in prison on count 2. Now, it is true the defendant has not been convicted of any felony offenses, and so he is eligible for probation on count 2 only. But were you to award him this, what you would be saying is that his behavior is only worth 10 years or below and to be released back out into our community. And what would that look like to let him back out in our community without paying for what he did for his action? Now I'm going to move on. In this punishment phase, you can consider all of the evidence that you received in the guilt innocence phase of this trial. And as he sits before you here today, his attorney has let you know that he rejects your verdict. And you all have rejected his claim of innocence based on all of the evidence that was presented to you all. And he stands here before you today asking for sympathy based on circumstances that he knew existed at the time that he decided to act in concert with Adis Hernandez Rivas and go and participate in the murder of Danielle Fernandez. He knew he had a wife and he enlisted her to drive them to the location. He knew that he had 3 children at that time. And what did he do? Tell him, yeah, come on, y'all sit in the back seat and watch me go and discharge my firearm at and in the direction of the complainant. When you heard the testimony of Roxana, they stopped at Kimberly Lane after Dairy Queen. And he had every opportunity to tell his kids, you know what, get off here. There's been absolutely no evidence, no witness that can corroborate this claim. And I want to urge to you all that if the statements of counsel are not in harmony with the evidence that you've received, you're to disregard them. Okay, there is no evidence that can corroborate this alleged threat by Adis Rivas. If you guys look at the video, and I'm sure you did, I asked you to look at it again, the video from 7718 Winsford Drive. I've already talked to you about the demeanor of this defendant and his body language. Compare that to the demeanor of Audis. Okay, he's standing outside of the gate in view of the camera, acting as a lookout until the defendant comes running out, and that is when he produces his firearm and shoots. And that's what he testified to. Now, we did talk about the existence of parole. You cannot accurately predict how it is going to be applied in this case, but just know that the defendant will be eligible to apply for half time. So whatever sentence or how many years you award him in prison, he will be eligible to apply at half time. So ladies and gentlemen, I again ask you regarding count one, I'm asking you if you believe, and I submit to you that we have proved beyond a reasonable doubt that this defendant was the mastermind behind this murder, then I ask that you sentence him to 45 years. If you believe that he had a lesser role than that, I ask you to sentence him to 35 years. And regarding count two, I ask that you deny his application and sentence him to 10 years and award a $2,000 fine in each count. Thank you.
All right, ladies and gentlemen, you'll be taking to the back to begin your deliberations. Everyone, please rise for the jurors. Everyone, please be seated. All right, and for those of you who are here, just request your inmates from the deputy and we will take your matters up.
Should I take the exhibits back again, Judge?
Just state defense.
How did I do?
Can't sign this part because we're not waiving appeal.
No, what ends up happening, you sign it, but you are waiving your appeal as far as it relates to anything that's not involving pretrial motions.
Right. It says for those matters were raised by
Special
written,
chair.
which we did.
Indeed it is.
Those will not be waived because that's what the paragraph says, but you still sign.
But no, it says I knowingly and voluntarily waive the right to appeal under one, which is written for trial.
Yes, if they're, so according to that, been told what they need to do, we're not doing it. All right, Delora, I am going to find that book. Now I'm on a search.
I sent you the.
Yep, this is the book. This is so the book. It brings back memories.
Okay.
Wait a minute, how many? Only one left in stock.
You might want to take it now, Joe. I want to beat you to it.
This is the discovery.
Okay, did you guys never read this book before? Are y'all too young?
Okay.
Real and make believe book.
Comes out, but I can't imagine the situation. He goes, no, I'm number one of the sexual assault. That's right. You see where there's that fighting. I don't see the point of that, so we'll have to do that. I don't know here. Then they probably need to, I think I rode that horse pretty hard.
Ah, okay.
You go over to
529-505. CMAC is assigned to case assessed. 5 days.
All right.
39.
All right, thank you. Could you have the interpreter come back down?
Does it say for charge 1 and 2 learn concurrently or stack on top of each other?
Oh, and I have my proposed answer.
Look the bottom row right here.
In the discussion report.
No.
All right, and so we'll just wait for your to come out. All right, anyone who's ready, just sign in.
Yeah.
Sean, we have a application. It's on Samuel Zamari. Court is calling 2026 CR 003085 State versus Samuel Zamaripa. Can I have parties announced for the record? And are you Mr. Zam?
Yes, ma'am.
Just 1 second, Odyssey. Counsel, you received all discovery and reviewed that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mrs. Zama, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mrs. Zamaripa, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, I did.
All right, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine.
I understand.
Counsel, has your client been able to provide you with any defenses?
He has,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does, Your Honor.
He's currently competent and was legally sane at the time of the offense.
Yes, Your Honor.
Mr. Zamaripo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
yes,
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
I understand.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, yes.
According to the plea, there's $1,000 fine to be probated. All right, just 1 second. Step aside. Who's talking to the inmates? Who is speaking with the inmate?
Right here.
Where? All right, you need to step outside the courtroom. You'll be called back in if you are needed as a witness, but you're excused.
Please wait outside.
All right, we're back on the record. So according to the plea, there's $1,000 fine to be probated. State is recommending deferred adjudication. They're taking in consideration 2026 CC 007642. Did you understand that as your plea?
Yeah.
State defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes,
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon. Did you understand?
yes.
Counsel, any such motions?
There was, Your Honor.
And outside the agreement, the state is requesting that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 100 hours community service restitution, the DOEP course, and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes,
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
no contest.
State any evidence.
Judge, we offer say exhibit number 1, including all of its stuff.
No objections to the proffered evidence, Your
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Honor. Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
yes, Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, after having gone over the motion to press, I think everything has been said in there. I think this is probably one of those one-off issues, Your Honor, but it just happened with 3 different factors in it. I do think we'll do everything he needs to do to be successful and finish out any kind of probation.
Just one moment, if you can step aside. We're back on the record in 2023 CR 4371B, State versus Marco Antonio Moreno Vasquez. Parties announced, please.
Next state.
Attorney for Marco Velasquez.
And we have an interpreter here.
Yes, Your Honor.
Yes, thank you. All right, the court received the following question from the jurors. Do the sentences for charge 1 and charge 2 run concurrently or stack on top of each other? Have both parties had a chance to review the question?
Yes, Your Honor.
And defense, have you had a chance to review the question with your client?
Judge.
The court proposes the following answer. With reference to your inquiry, you have all the law before you. Please continue your deliberations. Any objection from the state or the defense?
No objection.
No objection, Your Honor.
Any objection to sending the question and the answer back to the jurors?
No objection.
All right, we're on the record in 2023 CR 4371B, State versus Marco Moreno Vasquez. Could I have parties announced?
David A. Garcia, attorney for Marco Moreno Vasquez, Judge.
All right, and we have the interpreter present.
This is child license number 2203.
All right, thank you. Let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. Ladies and gentlemen, we have an interpreter here. You've seen him here before. He has taken the oath to translate as well. It's the court's understanding that you all have reached a verdict as to punishment. Is that correct?
Yes, Your Honor.
And is that a verdict on each count? And is it unanimous? All right, if you'll hand the verdict form to Deputy Laura, please. Thank you. All right, if the defendant will please rise. And count one, it states, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 40 years. That's 40. In addition, we assess a $1,500 fine. And count two, it states, we assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 6 years. In addition, we assess a $1,500 fine and that the defendant's application for community supervision be denied. Is there anyone who wishes to poll the jury?
We do, Judge.
All right, you may be seated. Ladies and gentlemen, to each count, I'm going to ask you if this is your verdict. If this is your verdict, I need you to respond yes. Does everyone understand? All right, we'll start from the end. Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
All right. In the back, is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
All right, ladies and gentlemen, Deputy Laura will take you back to the jury room and I'll come and speak with you briefly. Everyone, please rise for the jurors. All right, everyone, please be seated. All right, Mr. Moreno Vasquez, the jury having found you guilty, the court is finding you guilty in counts 1 and counts 2. And the jury's verdict of 40 years in count 1 with a $1,500 fine and 6 years in count 2 with a $1,500 fine. The court will enter those as your sentence as well. And count 1 and count 2 will run concurrently. And in count 1, there's an affirmative finding of deadly weapon. Let me see, could I see the indictment as it relates to count 2, please? Thank you, I'll have it. No, I was, because you were bringing it. Thank you. All right. Is there anything else with regards to sentencing from either side?
No, Your Honor.
All right. Mr. Vasquez, did you review the trial court certification of defendant's rights to appeal with your attorney?
Yeah, they told me it was for appealing, yes.
All right. And counsel, do you speak Spanish fluently?
I do, Judge.
And have you been able to communicate with your client with and without an interpreter?
I have, Judge.
All right. Then with regards to the trial court certification of defendant's rights to appeal, Mr. Moreno Vasquez, because this was not a plea bargaining case in a jury trial, you do have the right to appeal. All right. Is there anything else from either side?
Not from the defense, Judge, but if we can keep the interpreter here just for a little longer, I'll have my client sign a motion for an appeal.
All right. Thank you.
We can do Cooper's, I guess, whenever you want.
All right.
I've given that to the probation to read, and then I'll give it back if you need to read it again.
Yes, I'll need to read it because I haven't read it.
Just downstairs.
Yes, let me see. Who is here? The attorneys who are not here. All right, what is happening with Oscar Paul?
Please, turned in.
Okay, let me see. All right, so Carver Hall is going to be a plea. That's what y'all are saying?
Yes, I have to say.
Okay. And then on Juan Mejia, okay. And then Ricardo Adames,
We're turned in.
okay. And then Sabrano,
Plea paperwork turned in.
okay. All right, and then Max Perez.
I haven't heard from,
All right, recall that for the 23rd. And then Alcocer, all right, we'll recall it for Thursday. And then Morehouse, what day did we call that back for?
you said, on the 17th, like,
All right, the 17th. Bring her dressed, Morehouse. And then Charles Payne with Mick Aguilera.
that's the one that was reassigned to Charles Buck.
Okay,
He's up there.
all right, and you're working on Charles Payne.
Right, yes.
Okay. And then Geraldo Castillo,
That's gonna be a plea.
all right.
Can I click off it's a plea bargaining?
Oh, I do that. All right, Robert Galvan with Zachary Green.
I sent the settlement for that.
He came in and then he left. He's recall that for Thursday. He's on page 8, Deputy Laura.
Thank you, Judge.
And then Joe Cantu on page 11.
Thursday, Judge.
All right, Thursday. Dominique Smith.
Adrian Bettis has been, trial and
All right, recall that for the first week in August, what day?
I can do August 3rd.
All right, Deputy Laura, Dominique Smith on page 12 is August 3rd. James Price. Yes. All right, recall that for Thursday. Victor Mesa, that's Lindsay Shaw.
That's being taken care of by Joe.
Okay. Then we have, okay, that's Eric Cooper. All righty. Yes, yes. Yeah.
It's been a busy day.
Yes, ma'am.
Yes.
All right, who do you need to reset on?
Just Mr. Pena, I just got appointed today. I have looked at the discovery briefly. I have given him the initial offer, but we have a lot of work to do.
Which time are you asking?
30 days?
A 30-day reset on Pena.
Sure.
We'll put it down as discovery.
Yeah.
All right, are y'all ready on Cooper?
Yes. Yes.
Court is calling 2024 CR 08984 and 2024 CR 5691. State versus Eric Lee Cooper. Can I have parties announced?
Will Van Dieven for the state of Texas.
Charles Black for Mr. Cooper.
And are you Mr. Cooper?
Yes, ma'am.
All right. Did you review the motions to revoke community supervision with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Eric Cooper who was placed on community supervision in 2024 CR 08984 and 2024 CR 5691?
Yes, ma'am.
All right, state.
Yes, Your Honor, the state will be proceeding on the 2 violations of condition number 4 in each motion.
Okay. Can I have the file stamp for probation over there, please? Oh, Norman's grabbing it. All right, you may proceed.
Yes, Your Honor. Violated condition number 4. In Bear County, Texas, the defendant, Eric Lee Cooper Jr., did then and there fail to report to the supervision officer, was directed for the months of January, February, March 2026 in violation of condition number 4.
How do you plead to that, true or not true?
True. Additionally, Your Honor, the defendant violated condition number 4 in Bear County, Texas. The defendant, Eric Lee Cooper Jr., did fail to report to the supervision officer as directed for the month of December 2025 in violation of condition number 4.
How do you plead to that?
That's in both cases, Your Honor. The state will waive the remaining violations.
All right, and with regards, and I will, of course, disregard the violations, but for purposes,
Yes, Your Honor.
what is happening with these?
In terms of the family violence cases, I'm going to direct the misdemeanor prosecutor to reject them in recognition of this motion to revoke. We have never established contact with the victim in that case, despite multiple attempts over several months. She's simply beyond our reach.
All right, and with regards to the possession case?
Your Honor, the possession.
Been dismissed already, therefore a separate FDR.
All right. All right, did you understand by pleading true to violation of condition number 4 and 4 in each cause number, the court could find you guilty and sentence you up to 5 years in the prison and cause number ending in 84
Yes, ma'am.
and up to 2 years in the cause number ending in 91? Knowing that, do you still wish to plead true to 4 and 4 in each cause number? In each cause number, the court will find 4 and 4 true. Is there a proposed agreement?
Yes, Your Honor, the probation department at this time is recommending that the conditions be amended to include safe intermediate sanctions facility, substance abuse, followed by aftercare. I guess it's their presumption that this defendant has a substance abuse problem.
Wait, are you saying safe or?
SATF, I apologize.
Oh, no problem.
Or sanction facility. I apologize.
State ISF.
All right. And so I've read your letter. So why should I follow this agreement? And let me tell you why I'm asking that. I'm asking that because this is the second time you've been before the court for a violation of condition number 4. So I need someone to explain to me why you shouldn't go to prison.
I'll let you go first if you'd like.
So,
If you want me to talk to her, I will. I mean, I know if you want to talk to her, just talk to her.
so
You want to raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Cooper.
All right, so why shouldn't I just send you to prison? Because it appears to the court that maybe that's where you want to be. And when I say that, of course, nobody wants to go to prison, but I just go by actions, right?
Yes, ma'am.
All right, yes.
Honestly, I don't want to go to prison. I'm not trying to end myself in there, but I was in an abusive relationship. So where I was crying out for help, trying to get away from there. But
Abusive relationship. And what is this person's name?
Ariana,
I'm sorry, what? Ariana what?
so
All right, continue.
I was trying to cry out for her probation to see if I can go to a halfway house or a shelter. They wasn't trying to let me go there or anywhere else. They were just threatening me with jail time. So
All right, are you saying that you reached out
to my probation officer.
to probation?
Yes.
All right, does anybody have proof of this? Probation? Do you have any proof that he reached out to probation stating that he was in an abusive relationship?
To review the file.
Okay, she's gonna review the file. Continue telling me what else.
I wanted to get away. I didn't want to continue to be at that household, continue to get abused on. So took matters into my own hands when I shouldn't have, just up and left.
Yeah, but I don't understand the cutting off of the GPS. Because to me, if you're just gonna leave, you just leave and you leave with GPS on and probation will know where you are. So you cut off the GPS, then what happened?
Just left.
But he did contact immediately, shortly after the removal of the device, he contacted probation on his own.
All right, and so,
So he did stay in contact. I mean, I know it sounds interesting. It's documented that he contacted them after the removal of the device.
all right, so according to this, the GPS monitor, he removed it on November 26, 2025.
Correct.
When did he contact?
And I believe it says January of 26. He reached out to probation,
That's a full
trying
month.
to find help. Now, okay, and then on top of everything else, Judge, at the end of April of this year, he was at home with his newborn, and the newborn passed away in its sleep. So that's also, I believe that at the I facility, he can get some mental health help also, because he's really struggling with that. He's been in jail now for almost 3 months.
All right, and who's the mother of that child?
Jasmine.
And she was present this morning and she wanted to be here today, but she got called back to work.
Okay.
So she's present. That there is an autopsy that's being done. The results aren't back yet, but that's something that is also weighing very, very heavily on him. He's been in jail, unable to mourn with the mother of the child or anyone really almost since it happened. So I'm hopeful that he can get the ISF from the court and get some help, not just for the other issues that clearly need to be addressed, but also this issue that's been newly sprung upon him. That safe to say?
Yes.
Okay.
So when did his child pass?
April 30th,
And when were you arrested?
same night.
And have services taken place?
Yes, they have.
And were you available to be at the services? Or
I was trying to get your permission, but nobody from the jail would contact you, I guess. I don't know how it worked.
all right,
Your Honor.
yes.
With regard to the infant, there's a potential case being investigated regarding that. There's no information about it at this time. Case that's not being contemplated by this or MTR or any of that. That would be a future.
Absolutely. Anytime an infant dies in someone's care, there's an investigation. So, but it is certainly the understanding of myself, my client, that case is not involved in this agreement in any way, shape, or form. And if something was to arise, he would be forced to deal with that independently. So I think that's what the state, make sure that it's clear that we don't think that case is being TIC'd or not that there is a case. We don't expect there ever will be. But in the event that there was, we understand it has nothing to do with what we're asking the court today.
All right, I'm gonna give you a choice. Number one, I can revoke you and I'll sentence you to 2 years in each cause number, run concurrently. You'll receive credit for any time that you've been in custody, or I'll continue, they want you to go to state ISF followed by aftercare. Those are your two choices. Sure.
You stay on probation and you get help back. Once they release you from the program, you still continue to get counseling through probation.
And you get an actual counselor.
Yes, they will help you get an actual counselor. Yes. Sorry, my son's on emergency back pass.
Which do you prefer?
ISF.
All right, the cause number, the court is finding 4 and 4 true. The court will deny the motion. The court will follow the recommendation from probation and also the agreement of the state and the defense. And are you waiving your right to appeal?
Yes, ma'am.
The court is, in each cause number, is going to alter and amend conditions to include state ISF, and then probation, if you can have him evaluated for any type of trauma therapy. Is there anything else you need from the court?
I'm in therapy and I'm incarcerated.
You'll need to talk to them about that when you go there. And if there's some issue, just let me know. If they will
Can I
address that.
address right now?
I'm sorry.
To tell you about that right now?
Sure.
Okay, because I try to talk to mental health in jail. I write sick calls and all that. I get on the kiosk. I talk to classification, write grievances. Mental health doesn't.
Let me just tell you, we're going to make sure it's taken care of. That is why I always tell people, if you have an issue, you can come back to court and talk to me. I'm here 9 to 5, sometimes, well, really 8:30 to 5:30 or 6. And I tell people, if there's some issues, come in and talk to me, and they don't. So I can't do anything if people don't let me know what's going on. Yes.
And they did not recommend any further tests.
Okay. All right. Just do the trauma thing. Maybe he needs some trauma therapy. There we go. Is there anything else probation you recommend?
No.
All right. Thank you.
Right, thank you. And yes, of course. He's already been reset. It's already, no, let me think. Yes, Pena's already been reset. He's gone.
Your Honor, I believe that was the last family violence case. May I be excused?
Yes.
Thank you.
You're welcome. I'm sorry. Jesse Sambrano, attorney for Sam. Thank you. Court is called 2026 CR 005561. State versus Jesse Sambrano. Could I have parties announced for the record?
Charles Buck for Mr. Sembrano.
You're Mr. Sambrano.
Yes.
Counsel, you received all discovery, reviewed it with your client?
I have, Judge, and just let the record reflect, I was appointed today. My client and myself are both willing to waive any time requirements, and we're ready to proceed today.
Is that correct?
Yes, ma'am.
All right, no gum chewing.
Okay.
All right, and unfold arms. All right, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment?
Yes, ma'am.
Counsel, do you waive the reading?
I do.
State proceeding as presented.
On the left attempted CW.
Any objection?
No.
All right, probation, they're proceeding on attempted unlawfully carrying of a weapon with a felony conviction as a third-degree felony. Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the range of punishment is anywhere from 2 to 10 years in the prison, up to a $10,000 fine. If you have a plea, I don't have to follow it. If I don't and give you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, we have reviewed the discovery and gone over any possible defenses.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Has anyone threatened you, coerced you, or placed you in fear to get you in? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on the lesser included offense. Punishments be assessed at 4 years in the prison. There's a $1,000 fine that will be probated, and the state is recommending community supervision. Did you understand that to be your plea?
Yes, ma'am.
Defense and state?
Yes, sir.
Yes, Judge.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Any such motions?
No.
Outside the agreement, the state is recommending your community supervision be for a term of 4 years. I think I gave you the.
Yeah, I have it. Yes.
No, I gave you the wrong one.
I wondered, and I was looking at it like, what is that? Long day.
All right, 100 hours community service restitution, no possession of firearms or ammunition, no operating a motor vehicle without proof of valid license, or an affidavit of non-driving. Did you understand those were their recommendations?
Yes, ma'am.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
These receipts exhibit 1 and all attachments.
No objections.
All right, did you review the waiver and stipulations with your attorney, understand it, sign it in all the appropriate places?
Yes, ma'am.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, the state will be presenting evidence in the form of witnesses' statements and police reports, but there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept it into evidence and review the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty of the lesser included offense. Are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your
We
client?
believe he's worthy of the plea, and we ask you to follow it.
All right, are you employed?
Yes, ma'am.
What do you do?
I'm a tattoo artist.
Do you have any children?
Yes, ma'am. Actually, I have a 1-year-old at home and a baby on the way.
Hey, all right, this is what the court will do. Court is going to sentence you to 4 years in the prison, suspended and probated for 4 years, regular reporting by Zoom or in person, proof of employment within 45 days no employment as a home health care provider or with minors. There's going to be 100 hours community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits one time for 2 months. There is to be a gang evaluation, no possession of firearms, which you're not allowed to possess firearms. This is a felony conviction. There's to be no driving without a valid license. Do you understand?
Yes, ma'am.
And you need to provide that to probation.
Okay.
And there's to be regular UAs. Probation, is there anything else? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because it's plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
You had tattoos, the skull, does that hurt? Is that painful?
Yes, ma'am, I do.
Are you doing those tattoos now where people are put under and then they get the full body tattoo and they wake up?
I wish I could have done that myself, but no.
They say some people are having issues when they wake up from that, but all right. Good luck to you.
Thank you.
You're welcome.
Yes.
Ricardo Adames. Ricardo Adames, come down.
With this one, Judge, we have a motion to amend that we filed and presented to the principal.
All right, Chris calling 2026 CR 008349 and 2026 CR 008371. State versus Ricardo Adames. Can I have parties announced?
State.
Charles for Mr. Adamas.
And are you Mr. Adames?
Yeah.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading?
We did.
State and the cause number ending in 49. Are you proceeding on the indictment as presented?
Yes, Judge, after the urging of state's motion to amend.
We don't
Yes.
object.
All right, any objection to the amendment? And counsel, you received all discovery and did you review it with your client?
Yes, Judge.
And in each cause number, the court will find that the state is in compliance with discovery. And I'm sorry, and 7-1, are you all proceeding on the indictment as presented or waiving?
We're waiving the enhancement.
Again, no objections.
Admonishments in each cause number?
Yes, sir.
All right, in cause number ending in 7-1, you're charged with possession of a controlled substance, penalty group 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. In the cause number ending in 4-1, you're charged with theft of property as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to do that?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely.
Mr. Adames, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your
Anyone promised you anything other than the plea?
no one.
Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial and sign it in both places.
Yes, Your Honor.
By signing that, you waive your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Understood.
Counsel, any such motions?
No, Judge.
Outside the agreement in each cause number, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 100 hours community service restitution, no contact with the academy, SATF, cognitive thinking, anti-theft course, DOEP, random UAs. Did you understand those are recommendations from the state? And the court does not have to follow those recommendations. Then in each cause number, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, Exhibit 1 and I'll attend both causes.
No objections.
In each cause number, did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony.
Understood, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Accepted to evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, the court will find there's sufficient evidence to find you guilty. And in each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe the plea bargains were conferred after serious negotiations. We believe they're appropriate. We ask you to follow them. We understand that SAP is a possible condition. So if the court wants to order the SAP evaluation done in custody, in case that's the event, we certainly would understand.
All right, and the cause number 2026C008371.
Sorry.
Oh, no problem. All right. And that cause number, as previously stated, the court is finding you guilty. Court will sentence you to 6 years, suspended and probated for 5 years. Regular reporting by Zoom or in person. The UA hotline for 3 months with weekly testing. This is run concurrent with 2026 CR 008349. Proof of employment within 45 days of release. Knowing as a home health care provider or with minors. $120 restitution to the Bexar County Crime Lab for drug testing. In custody, there's to be a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, follow recommendations of TAP. 100 hours of community service restitution. Do you have children? Grandchildren?
Grandchildren,
And what are their ages?
2.
All right. Parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. Probation, is there anything else under that cause number? And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Understood, Your Honor.
All right. And cause number 2026 CR 008349, the court is going to find you guilty. Oh, state, I only had, maybe I'm missing it. Here it is. And that cause number, the court is finding you guilty. Court is going to sentence you to the court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years, regular reporting by Zoom or in person, UA hotline for 3 months with weekly testing. This is to run concurrently with 2026 CR 008371. Proof of employment within 45 days, no employment as a home healthcare provider with minors. In custody, there's to be a TAP evaluation and referral to felony drug court, 100 hours of community service restitution. I'm going to order the anti-theft course, the felony and anti-theft course. Once that's completed, community service hours will be deemed satisfied. Field visits 1 time per month until further notice. Taking consideration 2026 CR 008374 and 2026 CR 000313. There's to be no contact with Academy. Probation, is there anything else?
71, I'm sorry, on that day, the further notice,
Yes.
and that's all.
All right, in this cause number, is there any restitution state? All right, again, in that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, Your Honor.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. This is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you. Good luck to you.
Thank you.
No, she only gave me the other one.
I gave you 2. I gave you the first one, and then I didn't see the other one. Do you not have it?
Oh, I'm sorry. Yeah.
Okay, all right, thank you. Anyone else ready?
I have a gentleman in the box named Mr. Mesa. It's for a reset. He has an MTR, but he has a new sexual case.
All right, Mr. Mesa, what page is he on?
Probably on the MTR page, Judge.
All right, Victor Mesa, what we'll do is we're going to recall this and we'll set it for a contested in 45 days.
Okay, that's fine.
All right, Ms. Ferguson, I need a contested hearing date, 45 days. All right, and then counsel, if it's not going to be contested, if you'll let probation know 2 weeks out.
I certainly will.
All right, thank you.
September 8th. Got it. Okay. I'll be in touch. Yes.
Come on this way.
You can go.
So we're just waiting on the paperwork on Carvajal. Okay. And then that will be it, right?
Yeah, 30 minutes.
Oh, we're going to make it happen. And you know what? Who else can't happen? The attorneys can appear by Zoom. Oh, they can appear by Zoom or something. I mean, if all their paperwork, no, I'm saying if their paperwork is done. And when I say appear by Zoom on another date, not today. All right, Carvajal will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each cause number? Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Carvajal, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, ma'am.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
In each cause, well, not in each cause number, in the aggravated robbery cases, according to your plea, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon, no applications. These cases will run concurrently. The state is taking several cases into consideration, including 2025 CR 011310B. In the state jail felony, your punishment is to be assessed at 391 days in the Bexar County Jail with the judgment satisfied. Did you understand that to be your plea in each cause number?
Yes, ma'am.
Defense and state?
That is the plea, Judge.
Yes, Judge.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Judge.
State in 9B, you only have the affidavit.
Yes, that's all they included.
All right. Is there any objection to just proceeding on the affidavit and reviewing that?
No, I believe that's substantive.
Okay. All right. In each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Exhibit number 1, including all tests in all cases.
Any objection?
None.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it? Sign it in all the appropriate places?
Yes, ma'am.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. That means that the state will be presenting evidence in the form of witnesses' statements and police reports. But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Requirement defendant has knowingly and voluntarily waived and consent stipulation of testimony and stipulation. Court will accept into evidence states exhibits 1 and the court will review the same. And Norma, I need a reset date for a PSI.
September the 8th, Judge.
All right, September 8th. Okay. No, this is just.
Just
Well,
PSI.
copy that.
No, I do not.
Yep, just PSI. Cause number, court will find there's evidence to find you guilty, and the court will find you guilty. And in each cause number, even though the unauthorized use of a vehicle, I see that's a judgment satisfied. I'm going to bring back all cases on September 8th,
Yes, Judge.
and there's to be a PSI in each case.
Yes, Judge. Thank you
Thank you.
Thank you.
for that. I know it saddens you, but I think that's all I have with you today.
You're leaving us. All right, you and Cox are going to have to share that office that's in the back. We're going to put your names on it.
I was asked earlier on text if I brought a sleeping bag for today. So thank you, Judge.
You're welcome. Thank you so much. Oh, state
Yes, Judge.
cases that you're taking in consideration, you want to wait until sentencing?
That would be our preference.
Is this an application? No. All right, court is calling 2026 CR 000081 State versus Juan Mejia. Can I have parties announced?
Michael Collins, attorney for defendant, present and ready, Your Honor.
All right, and are you Juan Mejia?
Yes, ma'am.
Counsel, you received all the discovery. Did you review it with your client?
Yeah, Your
Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I do, Your Honor.
State, are you proceeding as presented?
We are.
Did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest, detention in a vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, and I believe he was, Your Honor.
Mr. Mejia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
We'll find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. This will run concurrently with,
It's 2 years TDC, Your Honor.
oh, that is so true. I'm so sorry. All right, 2 years TDC. You wouldn't want state jail felony time because that's day for day. 2 years TDC, concurrent with 2025 CC 006-987, 2025 41243, 2025 P 50734. Taking consideration 2025 PF 41242, 2026 CC 000524, 2026 PF 25278. Did you understand that to be your plea? State defense.
That is our agreement, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
So we offer you state exhibit number 1, including all attachments.
I've reviewed that with my client, Your Honor. We have no objections.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
We'll find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes. Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor. We'd ask that he get credit for time served that he has.
All right, the court will find you guilty, sentence you to 2 years in the prison, give you credit for any time served. This will run concurrently with the following 2025 cause numbers: 2025 CC 006-987, PF 41243, PF 50734. Taking consideration the following numbers: 2025 P 41242, the following 2026 cause numbers: CC 000524, PF 25278. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yeah, look.
All right, do better. You're too young for this. All right, good luck to you, okay? Geraldo Castillo, is calling 2026 CR 007863, State versus Geraldo Castillo Jr. Can I have parties announced?
Brandon River. And Richard Garcia for the defense, ready, Your Honor?
And are you Mr. Castillo?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I did, Your Honor, yes.
Court will find that the state is in compliance with discovery. Mr. Castillo, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading?
Yes, Your Honor.
State proceeding as presented?
Judge will be sitting solely on count 1, waiving and abandoning count 2 and the enhancement.
Any objection?
No objections, Judge.
Review the admonishments with your attorney. Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with manufacturing or deliver controlled substance, 140 to 200 grams. That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to do that?
Yes, Your Honor.
Counsel, your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Castillo, anyone threaten you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed on count 1 at 9 years in the prison. Did you understand that to be your plea?
Yes, Your Honor.
State defense?
That is the plea, Judge. Yes, Your Honor, that is the plea.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Any such motions?
No, Your Honor.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Exhibit number 1, including all attachments. No objections, Judge.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing the same, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we are.
Anything you wish to say on behalf of your client?
No, Your Honor, we're just asking that you follow the plea bargain.
All right, the court will sentence you to 9 years in the prison, give you credit for any time served. There's to be no residing in household with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, make better decisions. Don't build your happiness off somebody else's misery. And when you're selling drugs, that's what you're doing. Okay? All right, good luck to you.
Thank you, Judge.
Thank you.
Mrs. Speed, but she followed the plea bargain. You have no right over there.
We survived. But see, what I'm doing in this court right now, it's preparing you all for the zombie apocalypse. Because guess what? You don't know if the zombies are going to run fast or if the zombies are going to run slow.
Okay.
But here's the thing. You'll be able to continue. Yeah.
The stress management.
Yeah. And we are actually signed off. I don't know why this computer is doing this strange thing.
Like, what is?
You know, there have been these videos that have been coming up. They make the zombie apocalypse seem so great because they show them they're running, and then all of a sudden this attractive guy is running against it with them. And then they go to this bunker, and in the bunker, I think they're Asian because in the bunker, they're making noodles and they have all this food and it's storage. And I'm like, that's what I want.
That's
for my bunker.
on The Last of Us. Have you watched that show?
Yeah,
I need to watch it. I don't even like zombie stuff, and I watched it, but that's what my plan to survive the zombie apocalypse is to manipulate a man and to take care of him.
You know what? It can be done, but you got to make sure you get with the right person because did you ever watch the Book of Eli?
No, I haven't.
Oh my gosh. You got to see the Book of Eli. It's with Denzel Washington. It is so good. Then you'll realize, well, I just can't.
Rely on
Doesn't it teach you like you need to learn how to read Braille?
Yep.
Oh, you got to learn how to read and everything else.
Anything else in here, Jen?